Assalamualaikum and good morning everyone. My name is Nur Kaisara Damia binti Badrul Hisham. Today our group will be present the legal analysis for question 4 under business law, LAW299. This case involves a consumer named Mat Relax who purchased a home theatre system from Jaya Yusku Supermarket after watching a product demonstration conducted by Miss Yoda. Because he was excited by the demonstration, he bought the product immediately without carefully inspecting it. After arriving home, Mat Relax unpacked and installed the home theatre system in his living room. However, when he switched it on for the first time, the speaker suddenly exploded and caused him light injuries. Based on this fact, there are two legal issues. The first issue is whether Mat Relax can claim remedies and compensation after the defective speaker exploded and injured him. The second issue is whether Jaya Yusku Supermarket breached the implied condition by selling a defective product. Next, I will pass the presentation to presenter 2 who will explain the relevant legal principle that apply to...
And good morning everyone. My name is Hadi Samaki Sazali. Before explaining section 61A, we first need to understand the general rule in the law of sale of goods. Under the common law, the general principle survey and order, which means that let the buyer beware. This means that the buyer has the responsibility to check the goods before purchasing them and make sure they are suitable for the intended purpose. If the buyer fails to inspect the goods or choose unsuitable goods, any loss suffered will generally be the buyer's responsibility. In other words, the seller is normally not liable if the goods are not suitable for the buyer's particular purpose or do not meet the buyer's expectation regarding their quality. This general rule is reflected in Section 61 of the Sale of Goods Act 1957, which states that there is no implied warranty or implied condition regarding the quality or fitness of goods for a particular purpose. However, there is an important exception under Section 61A. This section provides that if the buyer informs the seller either expressly or by implication about the specific purpose for which the goods are needed, and the buyer relies on the seller's skill or judgment to recommend suitable goods, then law implies a condition that the goods supplied must be reasonably fit for that purpose. This protection only applies if the seller normally supplies those type of goods in the ordinary course of business. If the goods are not reasonably fit for the stated purpose, the seller will be in breach of the implied condition. As a result, the buyer may rescind the contract or claim damages. However, there is one exception. If the buyer purchases goods under a specific patent or trade name, no implied condition of fitness will arise because the law assumes that the buyer made an independent choices instead of relying on the seller's advice. Now, to rely on Section 61A, there are 4 requirements that must be satisfied. First, the buyer must communicate the particular purpose of the goods to the seller. This can be done either expressly or by implication, as long as the seller understands the intended use of the goods. Second, the buyer must rely on the seller's skill or judgment. This means that buyers trust the seller's knowledge and expertise in recommending the appropriate goods. Third, the goods must be of a type that the seller normally supplies in the ordinary course of business. This is because the seller is expected to have sufficient knowledge and expertise about the goods. Finally, the goods supplied must actually be reasonably fit for the purpose communicated by the buyer. However, this requirement will not apply if the buyer specifically chooses goods under a patent or trade name, because in the situation, the buyer is considered to have relied on their own judgment rather than the seller recommendations. That is the explanation of Section 61A of the Sale of Goods Act 1957.
Next, I will be explaining this situation based on the caveat emptor principle and Section 16 subsection 1 paragraph B of the Sale of Goods Act 1957, which deals with the implied condition as to merchantable quality. Under Section 16 subsection 1 paragraph B of the Sale of Goods Act 1957, when goods are bought by description from a seller who deals in those goods, there is an implied condition that the goods must be of merchantable quality. This means the goods must be reasonably fit for their ordinary purpose. The key points are that the goods must be suitable for normal use, and this protection applies even if the goods are sold under a patent or trade name. However, if the buyer examines the goods and the defect should reasonably have been discovered, this implied condition will not apply. The relevant case is Grant vs. Australian Knitting Mills 1936. In this case, the plaintiff bought underwear that contained excess chemicals which caused severe dermatitis after normal use. The court held that the underwear was not of merchantable quality because it was not fit for its ordinary purpose. This case established that goods must be safe and suitable for their intended use. Therefore, under Section 16, Subsection 1, Paragraph B, Mat Relax has the right to reject the goods, rescind the contract by returning the goods, and claim damages for the losses and the light injury caused by the defective speaker.
Assalamualaikum, my name is Nur binti Muhammad Arif. Besides the sale of good act, this case is also governed by the Consumer Protection Act 1999. First, Section 32 provide and imply guarantee that goods supplied to consumers must be of acceptable quality. This means the goods must be safe, free from defect, durable and suitable for their ordinary purpose. Whether goods are of acceptable quality depends on what a reasonable consumer would expect, taking into account the nature of the goods, the price and any claim made by the seller. Next, Section 33 provide and imply guarantee that goods must be fit for a particular purpose if the consumer relies on the supplier's recommendation or representation. In this case, Ms. Yoda demonstrated the home theatre system before Mat Relax purchased it. Therefore, it was reasonable for Mat Relax to believe that the product was safe and suitable for normal household use. Since the speaker exploited during its first use, both the guarantee of acceptable quality under Section 32 and the guarantee of fitness for purpose under Section 33 may have been breached. Next, Presenter 4 will apply these legal principles to the fact of the case.
Assalamualaikum, my name is Nurul Atar binti Yahya, and today I will explain about the apply the law to the facts of this case. Mat Relax purchased a home theatre system from Jaya Yusku Supermarket after watching a product demonstration by Miss Yoda. Although he did not specifically mention that he wanted it for home entertainment, this purpose can be implied because a home theatre system is normally used for home entertainment. He also relied on the seller's skill and judgment when decided to buy the product. Therefore, Section 16(1)(a) of the Sale of Goods Act 1957 applies. The home theatre system was sold by Jaya Yusku Supermarket, which normally supplies electrical appliances, and the product should have been reasonably fit for its intent purpose. However, when Mat Relax switched it on for the first time, the speaker exploded and caused him light injuries. This clearly shows that the product was not fit for its intent purpose. In addition, Mat Relax did not choose the product based on the specific brand or trade name. Instead, he bought it because he trusted the seller's product demonstration. Therefore, the patent or trade name exception does not apply. So, based on these facts, Jaya Yusku Supermarket has breached the implied condition under Section 16(1)(a) of the Sale of Goods Act 1957 because the product was defective and failed to meet its intent purpose.
Next, I will continue with the conclusion. In conclusion, Mat Relax is entitled to claim legal remedies against Jaya Yusku Supermarket because the home theatre system was defective and not reasonably fit for its intended purpose. The supermarket breached Section 16, Subsection 1, Paragraph A of the Sale of Goods Act 1957 by supplying goods that were not fit for the purpose relied upon by the buyer. In addition, the supermarket also breached Sections 32 and 33 of the Consumer Protection Act 1999 because the product was not acceptable quality and Mat Relax relied on the seller's skill and judgment. Therefore, Mat Relax may reject the defective goods, cancel the contract and claim damages for the injuries and losses he suffered. I think that is all from our group. Thank you for listening and thank you for your attention.